this has definitely got to be one of the weirder things out of this case. So this is a motion for reconsideration filed by Brett Douglas McDowell, who's not a party to the lawsuit, but he tried to intervene a few weeks ago, asking the court to allow him to be part of the lawsuit, essentially, because he claimed that there was some bad behavior by Ryan Reynolds, potentially, and Blake Lively. I don't remember if he also named her. But with respect to his IP, with respect to his person, with respect to his dog, and maybe his partner, and the way he connected all of it is that the nice pool character is the character that introduced dog pool. Dog pool is, in his view, clearly a way to make fun of his own dog, I think. Honestly, I haven't been able to pay super close attention to his stuff because it just seems so out there and irrelevant that I can't spend that much time on it. But I just find it interesting that he also asked for the judge to recuse himself because of some alleged conflicts of interest. You can intervene as a party if you're an interested party to a lawsuit. If, like, for example, a bucket of paint drops off a truck and explodes in front of your neighbor's house and gets 80% of it on your neighbor's house and 20% of it on yours. And let's say your neighbor sues the truck company or paint company, whatever. You, as the neighbor that had 20% of the paint splashed on your house, you are an interested party, because if the paint company is held liable for the damages to your neighbor's house, then presumably they would also be liable to the damages to your house because you've also been impacted by that harm. So that's really what a motion to intervene is meant for, is for a party that it could potentially also be harmed by the alleged bad acts or unlawful acts of the other side. So there really doesn't seem like a strong connection here on how this guy, Brett, is trying to tie the allegations that were made against Ryan Reynolds and Blake Lively to him. But when the court decided to dismiss the defamation claims and that dropped Ryan Reynolds out of the case, he also resolved this motion by saying, okay, those claims are not even here. So you can't even draw a connection because you have nothing to do with the workplace discrimination, harassment, and retaliation claims that are currently at issue. So he files this motion for reconsideration, which is something that you can file in lieu of an appeal or before an appeal. You're basically saying, like, judge, you just reconsider this motion because you didn't take into consideration, for example, this seminal case, or you completely ignored like these set of facts or this evidence, or it has to like be very, very, very wrong in order for a motion for reconsideration to be granted. But that's essentially what this is. I didn't read anything that out of this that seemed new or groundbreaking, so it will most likely get denied. But I just think it's such a random side story to all of this. I don't understand why he doesn't just file his own lawsuit against Ryan Reynolds or Marvel or whoever he has an issue with respect to dog pool. It just doesn't really make sense why, other than riding the coattails of publicity on this case, it doesn't really make sense to me why you would want to. And it seems like this guy is pro se, which means he's representing himself. An attorney is not acting on his behalf or filing on his behalf. So we do see this with people who are acting pro se. These days, we call it ChatGPT lawyering, because people will ChatGPT something and think that that's the law and then spit it back at you as if it's the law. Not that that's happened to me, but it definitely has. But yeah, so with pro se plaintiffs or parties or non-parties, they'll file something because they've heard of it or if they've looked it up. But this does not even rise to the level of actual consideration. So I can predict that this is going to go bye-bye pretty soon.